हेलो व्यूअर्स, आप सभी का हमारे यूट्यूब चैनल एसआरवी इंस्टीट्यूट ऑफ शॉर्ट हैंड सेंटर में स्वागत है। आप अगर हमारे चैनल पर नए हैं तो चैनल को सब्सक्राइब करें, बेल आइकन को दबाएं, जिससे कि हमारी हर नई वीडियो आप तक आसानी से पहुंचती रहे। स्टार्ट। मिस्टर राजेश कुमार, learned counsel for the appellants, has drawn our attention to the terms and conditions of the appointment with regard to the service conditions of the respondent and also to the communications between the appellant number 1 and the respondent stop. Learned counsel for the appellants submitted before us that the High Court was wrong and incorrect in holding that the order terminating the services of the respondent was stigmatic stop. It was also submitted that it cannot be said that the appellant number 1 was based against the respondent in taking the decision to terminate his services, as the board of directors was responsible for passing a resolution to the effect of termination of the services of the respondent after considering the entire records and performance and assessment report of the respondent para. Miss Sarita Dwivedi, learned senior advocate appearing for the respondent, on the other hand, submitted that a bare perusal of the order of termination dated 29/11/1999 would indicate that the same was stigmatic, and therefore the High Court was justified in setting aside the same, as the same was issued without giving any opportunity to the respondent and without conducting any inquiry in that regard. Stop. It was also submitted that the decision of the board of directors to terminate the services of the respondent was the result of bias of appellant number 1 and also influenced by him, as he was very much present in the meeting of the board of directors in which the decision to terminate the services of the respondent was taken. Para. In the light of above submissions made by the counsel appearing for the parties, we have perused the entire records. Stop. The respondent was appointed as executive director YD letter dated 3/6/1998 on specific terms and conditions, one of which was that he would be on probation in the aforesaid post for a period of 1 year from the date of joining the post. Stop. It was also stated in para 3 of the letter of appointment that if the aforesaid terms and conditions are acceptable to the respondent, he may indicate the date of joining within 10 days. Stop. The respondent accepted the aforesaid offer of appointment along with terms and conditions appended thereto, and also specifically accepted the position that he would be guided by the rules and regulations applicable to the appellant number 1. Para. We have already extracted the rule position governing the service conditions of the respondent. Stop. The respondent was ordered to be on probation for a period of 1 year, and as per clause 3.2 of service rules, his performance during the period of probation was to be reviewed by the company, and that the company could extended the period of probation or terminate the service of the respondent at any time or at the time of probation period. Stop. On the other hand, clause 3.3 of service rules stated there has to be an order communicating the order of confirmation to the officers concerned after the end of the period of probation stop.